our guest into tonight's conversation. Peter and I, our paths first crossed 25 years ago when our fiancés were doing the internship at Edendale Hospital in Pietermaritzburg, and they shared a house. And so we got to know each other during that year. And then our lives have kind of tracked each other in an interesting way. We both got married 2 weeks apart from each other. And 7 years later, our firstborns were born, I think, 1 week apart from each other. And then we both went on to have 2 other children after that. We've enjoyed great times together. We've hiked the Fish River Canyon. We've, of course, holidayed in the Drakensberg and bumped into each other on the beaches of KZN a couple of times without planning that. And Peter is an attorney at Tomlinson Gooney James Attorneys in Pietermaritzburg, where he heads up the Industrial Relations Department and has extensive experience in litigation and in mediation there. Peter was a tremendous help to me and to the Pinetown Methodist Church about 15 years ago when we had some HR challenges at the John Wesley School, and Peter's stepped in to help in an invaluable way. And so once again, I'm calling on Peter's friendship to help in this conversation, and thank you, Peter, for being available. And so let's just open our time together in prayer. Let us pray. Loving God, we thank you for the gift of Christian community, and thank you that tonight we can gather to share our collective wisdom, to ask honest questions as we seek to figure out how to respond as employers and as employees in an unprecedented time. And so we thank you that your Holy Spirit is our guide, and we pray that in the midst of our conversation that your wisdom and your way forward would prevail through our conversation. And we pray this in the name and spirit of Jesus. Amen. Thanks, Pete. I'm going to hand over to you now to lead us in the conversation, and then we will have an opportunity later to respond to questions people will type or ask. So over to you, Peter. Thanks.
Sure. Thanks, Ian. Hello, everyone. Good evening. Hope you can hear me. Maybe just sometimes when you have this type of conversation, it's quite nice to know where the person from that's leading the conversation or doing the input comes from. Ian has given you a sense of my background, but just in terms of law, I think it might be important that you know that I am in private practice, and a lot of that private practice I will act for employers, some small, some medium, and I do act for some of the big nationals. I do, though, have something of a history in the union movement, and I've represented fairly extensively some of the unions. That just gives you a sense of where I'm grounded in the law, because obviously in any of these kind of conversations, if there is a bias, you should be able to at least have a fighting chance to identify that. What I thought is that I would just start the conversation by giving you some sort of sense of where I think we are in terms of what I will call employment and labor law. So just identifying some of the phases that I've seen that we've come through and trying to identify now in what I will loosely call a phase. And hopefully, if you've got any involvement in that, whether you're an employee or an employer, you will be able to identify some of those. I think, though, it's important, the beginning remarks is that employment and labor law really are living the same experience as everyone is living in all aspects of their lives. I think we've got to a point, or we've come through, certainly in the COVID stages, the lockdown, and then even post-lockdown, to a situation where if you had got the drafters of the Constitution, of the Labor Relations Act, of the Basic Conditions of Employment Act, and then through to, for instance, our Employment Equity Act, etc. They would never ever have contemplated that we would have a scenario as we do now. So all of the legislation and all of the law, and even if you go a step further than that, all of our jurisprudence, what we mean by that is all the case law that developed and the thinking around that, never contemplated what we are facing now, which is interesting, because what you get is you get a situation where the practical realities catch up and overtake the law. And when I say, well, you may ask, well, what am I talking about there? It's the fact of the matter is that in crude terms, what happens is that there's so many people and so many employers and possibly employees that are doing things that were not contemplated by the law or are unlawful, that you actually get to a situation where it renders it almost practically meaningless. So for instance, the enforcement of certain employees' rights. There are just so many people that would be in the queue related to the same thing that you have a practical problem. And it's interesting from a point of view of, well, what is law, and philosophically the compliance with law, and then through to the horrible crude end where an employee needs to enforce rights, basic rights, and how do they do that? The other day I was in CCMA in Durban, and for an arbitrations that have started happening again, and there was a queue which was down the road and around the corner at social distance, and though a commissioner told me those are all people now that are coming with various complaints from not being paid related to retrenchments. So we are facing that practical reality, and that I think is important for any conversation like we are having, to understand that is the practical reality, and then start to think about, well, what is that actually going to mean for the law going forward, and for us as a community or society going forward. Now, just in terms of the phases that I identify, I think it's important for us to identify that before COVID came along, things were not good for employers or employees. We'd come through another wave of retrenchments, and that usually is one of the strong indicators of what's going on in the economy, but a stronger sense of whether there are any employers that are hopeful or are taking risks or are expanding. We seem to come out of elections, etc., and everyone was waiting and hoping, and nothing seemed to happen. We got into the new year not expecting anything else, and then COVID came along. Why do I make those comments? It's not necessarily to make you feel desperate, etc., but really that was the background going into COVID. What we then had is that we really had, in employment law terms, COVID was sudden. There wasn't a lot of planning, and there certainly wasn't any legislation or thinking around it before it happened. Then COVID happens. And really, the only way to describe COVID in employment terms is that you have this outside intervention. In legal terms, people, you may or may not have read or seen or discussed the concept of force majeure. That means that in a contractual situation, the two parties who have contracted with each other, something happens that is bigger than both of them and of which they have no control. And what it means is that in legal terms is that the contractual obligations between the two parties are either suspended for a period of time, or depending on the nature of the contract, they are extinguished. Now, that was the first time in the 23 years of doing employment law that I ever saw that concept in application in employment law. But essentially what people were saying, COVID has come along, employers have no obligation to pay them or to provide work for them and or to pay them, and employees are in the situation, well, they're not obliged to and there can be no implications in the fact that they don't provide their labor. In other words, they don't go to work or do their work. And that really came for that period of lockdown when we were in what I'll refer to as total lockdown. And whilst that wasn't easy on the individuals, the legal kind of framework was easier because it extinguished the obligations for both. You obviously had things like the TERS applications, then that came into play because from a government point or a governance point of view, the government realized that it was going to have to step in and provide some support. And that's really what that was. All it really did is give us an indication that the government was accepting that the obligations in terms of the employment contract would be extinguished. And you can see in some of the early regulations and communications from government, they were essentially pleading with employers to come to the assistance of employees. The next phase that we entered into is as the economy and the regulations, as we dropped the levels and businesses started to operate again. You had what I will refer to as the opening up phase, and employers and employees didn't know where they stood there, and there was a large emphasis. The emphasis there was on keeping workplaces safe. So employers had a lot of scope to arrange their affairs and even determine what employees would be doing by, I don't want to say hiding, but certainly using the regulations to say we cannot go back to normal because the regulations are such that we have to provide a safe workplace, and therefore employees can't come back full time to their usual hours. We're not operating on the same basis. And essentially when you came through March into April, you mainly had full lockdown, no one got paid, or there was no obligation to pay. TERS payments came. Then when we went into May, some opened up, and we were left in a situation of both employees and employees where no one exactly knew where they stood. And we really are dealing with a situation there that once you opened up, the contractual relationship between the employee and the employer, you no longer had this intervening COVID, and really those obligations of the employer and the employee should have been restored. But it wasn't that simple because you had the COVID regulations relating to safe workplaces, the number of people that you could have in your workplace, and the greater difficulty that employers were having is that they were open up again, but in fact they weren't working. In fact, there was no business, even in circumstances where that part of the economy or that sector was open. So you had almost like a bit of a twilight zone in that opening up. We've now moved into what I would refer to as full opening, and it's left us even more uncertain. And in fact, things are now coming to the fore or coming to a head. They were uncertain whilst it was opening up, and now we are dealing with the full difficulties, because employers are no longer in a situation where contractually they can rely on the fact that there is an outside force. The practical reality is that a lot of employees haven't gone back to work, certainly on the same hour, for the same hours and for the same pay as they were. And we've got to a situation where people are, to a large extent, a lot of people are uncertain, for instance, even what their hours or their remuneration will be in the given month. And where we're sitting now in June. When you start looking at that, the legal position is that really it should be restored. The practical reality is that it's not being restored. We then get a further dynamic on that because many of the employers have now started to engage in what in employment law we would refer to as Section 189. Those are the processes that you initiate when you are going to retrench people. So in other words, there's a legitimate operational requirement for you then to terminate contracts of employment, what everyone would commonly understand as a retrenchment. The difficulty that we have seen in the practical realities of that, we have a number of employers around that, in fact, do not even have the money to retrench. So in other words, they can't actually retrench the employees because they'll, on termination of retrenchment, there are monies that are owed. Those monies are the severance in terms of the basic conditions, which would be a week for every completed year of service and a month's notice, and you'd have to pay out leave. There are many small and even medium-sized employers that actually can't retrench their people because they don't have the money. And in fact, if you terminate it and don't have the money to pay the retrenchments, that's, in terms of the Insolvency Act, that's an act of insolvency. The business is then in distress, and the implications for that. I've had many employees get hold of me in that situation asking me, is there not a mechanism where I can force them to retrench me so that I can take the retrenchment package and move on? The answer to that is no. That's fairly clear in law. You can't force to, but you do have individuals now, and I think that's an area of the law that may develop where they're not getting paid, they're kind of hanging, and there has been no initiation of the Section 189 process. Then on bigger retrenchment in bigger workplaces, you're dealing with what are called Section 189 capital A's, and those are what we would refer to as big retrenchment. And in a fairly recent amendment to the Act, it gives a 60-day period before you can terminate. And that 60-day period is so that particularly unions can get in a facilitator from the CCMA or the Bargaining Council, and also gives them an opportunity to strike in order to prevent you from retrenching. We are seeing none of that, and all that's happening is that 60-day period has become like a rod around people's neck, both employers and employees, because people don't want to wait out the 60 days because no one's getting paid, and they want to accelerate that. So we spent some time thinking around how we can short circuit that for everyone's benefit, and have proceeded on the basis that if people enter into written agreements, well, then they can do that. But it gives you a strong sense of where people are at in there. So that's really how I identify the phases. And then maybe just from telephone calls that I've been taking and people that I've been speaking to, a question that keeps emerging is people that are predisposed or have underlying conditions or comorbidities or whatever the correct technical term is. So in other words, it's they taking risk when they go back into the workplace. There has been some confusion over that, and there has been confusion over people that are over the age of 60. That's really been clarified to a large extent in the latest regulations that have come out from the Department of Health. There is nothing preventing people that are over 60 from returning to work. And it's not that an employer can refuse to take people over the age of 60, nor can they refuse people that are, for instance, HIV positive, or people that are diabetic, or people that have heart conditions. What the law is, very broadly, is that the employer is required to provide a safe working environment. And part of a safe working environment includes that it must be safe from or there must be reasonable precautions taken to prevent you getting infected by the COVID virus. In circumstances where a doctor certifies or a doctor indicates that someone has comorbidities, or indicates that the person is at particular risk if they get COVID, that does not preclude people from working. What it means is that an employer must provide a safe working environment. They must try and allow them, for instance, to work at home. But for the large majority of the country's population, that's not realistic. But they have to take precautions in their workplace to ensure that the person is safe. So by way of illustration, my secretary has an underlying heart condition, and that also affects her breathing. It's the last thing in the world that I want is for her to get infected. But the special circumstances, she works at home, as much as she can, but she does need to come in from time to time. She then sits in a separate area where she is isolated. She doesn't have to deal with members of the public, and for instance, her area is sanitized again before she comes in on each occasion. That would comply as a special circumstance in what we are talking about. Why I raise that is that I've been asked a number of questions regarding that, and I thought that may initiate some discussion, or people want to ask that question, but they think they're either shy or they don't think it's a good question. It's very relevant. Those are my initial thoughts, and then I would like to be directed by where people are at and the questions that they have, and I will try to input on those if I'm able to do.
Thanks very much, Peter. So this is a time now for people to come forward with questions that you might have. And while you are either typing or getting to your unmute button, Peter, just to ask you, the term that you used for when the legal term for when contractual relationships are extinguished or suspended, can you just tell us what that term is
Sure.
again, please?
Okay, force majeure. Ian, that's a concept that comes from civil law. So you will often find in civil contracts there will be what is called a force majeure contract clause, and either the parties will contract and say, well, if a force majeure comes along, we agree that this is what will happen. If there's no contractual clause as regards the force majeure, it's accepted that it's beyond both of what parties contemplate. It's beyond their control. And in civil law, you get times when it is temporarily suspended. So for instance, that may be in a lease agreement, or it's permanently extinguished. Say, for instance, that's possible in a supply contract, for instance, that you no longer are actually able to carry out the obligations in terms of that contract. It was accepted that when we initially went into COVID, everyone understood this to be temporary. People are now thinking about whether in certain circumstances it hasn't permanently extinguished because of the fact that some businesses will not get up and actually get going again. Okay, but that's a moot point. I think we would all accept that in mainstream law, people would accept that the employment obligations were suspended for a period of time, but we've now come out of that, and it's back to the obligations of both parties.
Okay.
Yeah.
Okay. So if anybody would like to type your questions, you can do so either in the panel, and so I see Michael Gill, who's the principal of Westview College, our primary school, has typed a question. He's asking, what is the furlough of workers and how does it work?
Okay, that's a very good question. That furlough, the concept, I think it's an old English law concept. But really what you're talking about there is that people are put on unpaid leave. And that is one of the points that I was making about the practical realities catching up to the law and overtaking the law. In the normal course, there is no provisions where you can just put employees on unpaid leave. Right? You get concepts of what is called short time. So for instance, in production, in manufacturing environments or other environments where there's a downturn and workers are told, well, instead of working your 45 hours this week, you're only going to work 20 hours, referred to as short time. Short time, certainly constitutionally, is very contentious. And in fact, you can find case law, I'm talking about pre-COVID, where judges at the labor court reject the fact that such a thing as short time exists. because it's just simply a unilateral change to terms and conditions. However, it persists because in certain industries, they have what are called main agreements. So for instance, in forestry, metal and engineering, those are just two examples of sectors that would have their own main agreements. They have provisions in those main agreements whereby employees can go on short term, but there are certain procedures that you have to follow. So that you understand that. So for instance, in forestry, when there's bad weather and they can't get into the plantations to fell, for instance, they'll have a provision whereby they've got to give certain notice and they can go on short time, but only for a period of time. And the period of time is stipulated. It's not a permanent thing. When we've gone into COVID, this concept of furlough has emerged, and it's the whole idea of putting people on unpaid leave. All right, and people have been using it, but in terms of legally, it's a legal uncertainty. Okay, without agreement, all right, it is a legal uncertainty. When we initially went into lockdown, people were trying to grapple with the idea of, well, when people go on lockdown, what are they actually going to be on? The answer to that question is that it is a shutdown, the obligations are suspended. But in order to assist employees, some allowed employees to take leave at that time, and there were other mechanisms. Some, they referred to them as placing them on unpaid leave or furlough. It wasn't an adequate explanation for what was going on in total lockdown. And now what has happened is that as people have come out of lockdown and they are dealing with the fact that there isn't work to do, they're using this concept of furlough, or they just send people home and they put them on unpaid leave or furlough, right? And there is legal uncertainty there. You can't say to an employer, well, you have the right to place people on furlough. You don't in terms of any practical reality. People are doing it, and people are just saying, well, we'll make a TERS application for you, and you just until we call you. That is not adequate in terms of the law, certainly as I understand it, and it prevails at the time. However, what has happened, and that may be part of what the question is that's been asked, is that some employers have reached agreement with their employees that rather than starting to retrench them, that they would try and wait it out. And the way to wait it out is that they would agree to go on unpaid leave or furlough, it's being asked, for a period of time in the hope that things would pick up and they would be able to restore their contracts of employment before going down the path of Section 189. And the only thing as regards that is that I have been asked that question a number of times. Can we simply put people on furlough? The answer is no. You would have to reach agreement. I hope that answers.
So, Pete, what advice would you give to an employer who reached a stage where they couldn't continue with their staff, but they were fairly confident that once we were through the pandemic, they would be able to re-employ? What would your advice to them be?
My advice there is to deal with your employees as people, not in terms of the provisions of the Labour Relations Act. So sit with them and tell them what the situation is. Generally, things are so tough for both employees and employers that you are reaching agreement, and the fact that people will sit it out, that you'll do your TERS application and you will sit it out. That's the way to do it there. And what is interesting, in asking that question, it's interesting. There's a category of employee, and it's not the lowest wage earners. Wage earners will agree with you to sit it out because a wage earner generally has to live with that hope. You've got a category of, in terms of the country's average wage or remuneration, they would be high earners. They are the more difficult people. There's a class of people in there, technically skilled, that are giving employers a hard time related to that and demanding things. the most vulnerable people are in a situation where if they know that their TERS application is being processed, they generally, and they believe that the employer is trustworthy, they'll sit it out. So that's what I would encourage people to do there.
Thank you, Pete. Okay, we've got a couple of other questions.
Sure.
Kulu is asking to explain the difference between 189 and a 189A. And then
Okay.
after that, we'll get onto Johan's question.
Okay, Kulu, good question, because it's 189 is the general provision. 189A, that A always gives you an indication that it's a later insertion. It was an amendment. It's what is referred to as big retrenchment. It's for employers that I think offhand, think it's employ over 50 employees and are going to retrench approximately 1/10 of their workforce. So when you're dealing with 100 employees, when you contemplating retrenching 10 or more, up to 200, then it's 220 or more, so approximately 1/10. Then different provision apply. The process is very similar, but the time frames are different. And why the time frames are different is it gives both parties the opportunity to get in a CCMA or a bargaining council facilitator under certain circumstances. And then also the time period from the time that you initiate that 189A. So from the date that you issue your first notice, you've got to wait a period of 60 days before you can issue letters of termination. Doesn't matter how long your consultation process takes place. So you can see in those big retrenchments, the issues of the 60 days has become a very hot issue because people are saying that they can't wait the 60 days. And the law says that it's unlawful to terminate before the 60 days. The only way you can is if you get the individual agreement of each one of those employees that you can shorten that time period. The actual process that you use in terms of consulting is almost the same, very, very similar as the consultation period or consultation process in 189. So that's the difference.
Thanks, Pete. We've got one more question under the chat, and then we've also got a couple of questions in the Q&A.
Okay.
So we'll start with the questions under the chat.
Okay.
So this is from Johan saying, our housekeeper commutes daily from Maloto. With COVID, we're not comfortable with this. For example, Patco bus, etc. We're considering only in future offering her a temporary position, but it will be well into the future next year. The possibility is to terminate her services over the short term, sad as it may be. She is currently receiving UIF. Your advice?
Okay. There, in terms of where you're dealing in the domestic worker sector, there's nothing currently that prevents people from working. So you would get a restoration of the contracts of employment. In terms of the commuting, when it said, well, we're not comfortable with this, that wouldn't be any grounds. If the person has to take public transport and come to work, there are regulations relating to public transport, etc. And so that would not be a ground for any implications for her employment, because of if that is what is being said, is that it's that the employer is uncomfortable with her commuting and therefore makes the household vulnerable. That wouldn't be a ground, because there are regulations, and chances are, I mean, statistically, I mean, for instance, in circumstances like in my home, we have a domestic worker, and statistically, I would imagine, statistically, the chances of her getting COVID from us are much higher than her ever giving us COVID, just by the nature of where we live and what we are involved with work-wise and who we come across. So I think one might need to be a little bit careful there. And then it says we are considering only in future offering her a temporary position, but it will be, I'm not sure that I understand that. Look, we could, yeah. So, sorry, Ian.
So I was just going to ask Johan if he could clarify that,
Okay.
his question about the temporary position.
Yeah.
And let me see if
yeah,
I
there's
can.
no, look, what has happened is that, I mean, in certain circumstances, I think that people have all started to look at employment slightly differently, and including those that take public transport. One of the interesting things has been realizing what people have to do to get to work, etc. And I have seen a couple of scenarios, for instance, where people have decided or have reached agreement with their employees, for instance, to work longer hours on certain days so that it cuts down the number of trips that they actually have to make. And a number of those have actually been quite creative. You know, in a domestic worker setting, it's impossible. The person needs to do their duties, you know, in the domestic setting. But in others, and even where in certain productions, that even the unions have agreed. And what has been interesting is that it saves people so much on transport that in fact they are often quite agreeable to that. So that may be buried in one of the solutions to what has been raised there in terms of the domestic work.
Thanks for that, Peter.
Sure.
Yeah, I can clarify the point if it's okay.
Sure.
Thanks, Johan. Go ahead with that. Yeah.
I think at the moment she's employed full-time, but one looks at the requirement, you know, and what's expected from her. She only works about 4-5 hours every day, but she's a full-time employee. So in terms of what you say, coming in 2 days, we don't really need her for 5 days. I think it was just doing the right thing. Is also in terms of what is happening with my business, one looks at affordability, you know, so what can you do? And yeah, that's basically the point I'd like to make. So we're thinking of the possibility of laying her off, but yeah, it's not an easy decision.
Certainly. Johan, you in law, you're dealing with what Section 189 refers to as an operational requirement. Your requirements are, you may only need someone for 3 days a week, or you may only be able to afford it for 3 days a week. That is an objective operational requirement, and then certainly in terms of the law, you then could bring about either a change to her terms and conditions, so to reduce the hours, or you could get into a situation where you could retrench her if that doesn't suit her. So for instance, if she needs to be employed for the full 5 days, or she doesn't have other employment, etc. But you clearly have when you explain it as you do, you clearly have an operational requirement for certain hours. There's certainly nothing wrong in law, and you would do that by trying to negotiate lesser hours with her in circumstances where that does not suit her, or she doesn't want to do that. Then you would have a right in terms of, as long as you follow the provision in terms of 189, you could do that. Certainly not a difficulty from a law point of view.
Okay, thank you. So then the questions under the Q&A are both related to UIF. The first one is, if an employer has not paid UIF for the employees, what can they claim? Is this where the TERS is meant to help them? And then I'll give the second question, because I think it's similar, Pete. It says, what recourse has the employee got against the employer for not registering and paying UIF?
Yeah, when you go and read, initially they were saying TERS was only for employees that had registered. So that was one of the elements that had to exist. In a later regulation, I did see that they indicated that an employer could now register, and that would mean that there would be penalties to pay, etc. And then the TERS application could go through. So the answer to the question is that it's for registered employers. And even in circumstances where they hadn't been registered, unless they go and register now, there's going to be no TERS claim. Then the second part of the question is that what recourse has the employee got against the employer for not registering and paying UIF? In terms of UIF legislation, there's certain compliance issues and penalties that the employer would be liable for. But what the question there that Nick is asking is, what recourse does the employee have? And my answer to that is that theoretically in law, they would have a claim against the employer for the value of any TERS claim that they would have been entitled to. The difficulty is that they're going to have to enforce that claim. And the difficulty is that if you're dealing with an employer that hasn't registered for UIF, can you imagine? And I think the Labour Court would be sympathetic to that claim. And I think that there would be a claim in law, but you're going to have to enforce that claim. And when that's legal speak for once you've got the judgment against them, if they hadn't been paying the UIF money, hopefully they've got something else that you can attach to actually recover that. But it does theoretically, in my view, exist. Practically doesn't help someone because the TERS claim they need now. And you're going to ask me, how long is it going to take to recover that claim against the employer? And it's going to take you conservative estimates, months and months. Most unfortunate situation.
Thanks for that. Pete, we got another question in the chat column. Kulu's describing a situation where a domestic helper stops visiting her family over weekends because she might get infected when away. Kulu, I'm guessing that you're saying that the employer is requiring that the live-in domestic worker doesn't visit her family. Perhaps you can just confirm that. And then, true. Is that what you're saying? Yeah.
Yes, thank you.
And then you're asking, is that requirement, would that classify as constructive dismissal?
Yes.
Okay.
Would that be wrong? Yes.
Kulu, sorry, I'm trying to process that, because the idea of a domestic worker not being able to, or a demand being made that they don't visit their family, it's just too awful to contemplate. But I'm now trying to, I'm of the view that it cannot be a condition of employment for a domestic worker. The reality is that there are regulations. People are allowed to move. They've got a social distance. They're entitled to go home to their families in law. It cannot be a condition. And why I'm being apprehensive is because the last part of what you're asking me is what a constructive dismissal is a constructive dismissal is when an employee gets into a situation where continued employment with the employer is wholly intolerable. That's the legal test. And so then leave the employment contract, but it is a species of dismissal. And as labor lawyers and employment lawyers, we are very, very slow to advise people to go the constructive dismissal route. But you've given me a scenario this evening which may get you very, very close. Okay, I just don't know how else to describe it other than being awful. And awful is not a legal test, but I think that on a on a basis of fairness and a basis of legality, you would come close. It's not a condition that you can
Impose.
require of your domestic worker. And then the reality is a constructive dismissal. The problem is that, yeah, again, people no doubt are trying desperately to hang on to their employment, and so don't want to walk away from it in the hope that they would have a claim for compensation.
Okay, thank you.
Sure.
Okay, I'll just give a minute or two in case there are any further questions that anybody would like to address to Peter.
Yeah, just while people are thinking, maybe I mean, I'm just, maybe I'm presuming, and that may be incorrectly, but you are all part or somehow connected to the church community. One of the things that you may want to think about and reflect about, and maybe that can also be part of your prayers, is the fact that for me, a very big concern is that as we come out of COVID, what happens is that you get a further what is referred to as a casualization of work. So there's less certainty for people in permanent work and security. So you get all of these atypical forms of work that emerge. And to me, when I look at this, many employers are taking this as an opportunity to casualize, to make work atypical. And it doesn't, in my view, and that's not necessarily a legal view, it makes people's lives less full and less rich. They can't live in hope because they just have no security any of the time. And I think that's something, certainly as people of conscience, that you might want to think about, and encouraging those that you know and those that are part of your community to actually not allow that to happen, but to look for permanent sources of real and proper work that is remunerated at a level that is that people can live on. And that is a real challenge, particularly in times when the economy is so poor, and most of us that are involved in businesses are just fighting to survive. So that's really the challenge.
Thank you, Peter. That's such a helpful, perhaps a good place for us to end, is to just be reminded that in all of these conversations, we are not just talking about cold, hard law, but we are talking about human beings that are made in the image of God, and that our faith should infuse all of our relationships, including our relationships with our employees and our employers. And as you rightly say, navigating that space is difficult in such times, but part of our role as community is to inspire each other and assist each other to negotiate and to navigate that space. Okay, if there's no further questions, I think we're ready to end our webinar. So just to say a huge thank you to you, Peter, for your time and for your availability to be a part of this conversation, and for the response that you've given, not just to the questions, but also helping us to understand the different phases that we are in as far as legal law and this pandemic are concerned. So
sure, Ian.
Okay. So if there's no further questions, we'll say goodbye. And I'm going to ask that we finish, if it's okay, if it's possible for you. I'm not sure if it's possible for everybody else to turn on the videos. I've been a part of many Zoom meetings, but this is the first time I'm doing a Zoom webinar. So I think it might not be possible for attendees to turn on their videos, only panelists. Okay, and Sipiwe is a panelist. So we won't be able to turn on our videos to say goodbye, but perhaps you can all unmute yourself and we can just say goodbye to each other. And then I wish you well as you go into this evening. Thank you very much to all of you who have participated.
Goodbye. Thank you very much.
Cheers.
Bye-bye. Thanks very
God
much.
bless. Thanks,
Go well,
everybody.
everyone. Okay.
Bye.